Hello, welcome to Legalese. I'm attorney Christopher Lilly. I'm your host. We're joined today by attorney Andrea Wells from the Levitt Law Group in Chelmsford. Welcome, Andrea.
Thank you for having me.
Thank you for coming. Legalese is a presentation of the Northern Middlesex Bar Association designed to bring topics of interest to the community for your understanding and education. Today's topic is alimony. We've heard of alimony reform that occurred in 2011, and we felt it's a good time now to bring forward to the public an understanding of what alimony is now as it's reformed, hence the topic, hence the title, Alimony as Reformed. Andrea practices quite a bit in the area of family law and the family and probate courts, having her office in Chelmsford. And Andrea, I'm going to ask you to describe for us, first, what is alimony?
Alimony, I guess at its base, is a payment of support to a recipient in need from a payor who has the ability to pay.
Okay, and it comes up in the context of family courts and in marriages and divorces.
It comes up in divorces, correct.
And it has recently undergone a Reform Act.
Correct.
In 2011. What occurred in the course of alimony reform?
So there were a lot of things going on in the court, and a lot of people who were sort of unhappy with the state of alimony. It is sort of a archaic idea, and it is one of those areas that probably causes the most tension in these cases, sometimes even more than a custody issue might cause people. So even the word alimony seems to be pretty charged sometimes. So with the number of cases that had come down, there was a lot of noise within the bar and in the bench and in the legislature to reform that, to make it more in line with society today, I suppose, and addressing some of the areas that people felt were unfair, unjust, and
what were some of those areas?
Well, so for example, Massachusetts is one of those states that would have, quote, lifetime alimony, and you could be in a situation that it goes on forever until you die or your former spouse were to die, and that is one of the big changes that we had in terms of durational limits that have now been put on alimony, particularly if a marriage is less than 20 years. And we can talk a little bit more about some of the things that have happened since the statute took effect, which it took effect in March of 2012. So we can still have indefinite, if you want, alimony in a long-term marriage. But it also can terminate on someone reaching a retirement age. And that was another one of the big concerns for people. And there was a big case that came down called Pierce that somebody was required to continue to pay alimony even though they had retired, and caused a lot of controversy. And that was one of the bigger things that spurred on the alimony reform law.
That was dealing with a situation that involved somebody who had an alimony order prior to the passage of the
oh yes, right. That case came down, and it was somewhat surprising to the bar and how the court had interpreted this particular couple's separation agreement, and ordered that alimony would continue even though the husband had retired.
So that's the difference between prospective or retrospective application of the law.
Right, right. And the termination upon someone now under the new alimony reform law that terminates when somebody reaches their Social Security age, sort of the full retirement benefit under Social Security, which for most people is 66 or 67, depending on when you were born. That's new. But there has been case law, so we have our statute, and we can all read that and think what we want to think it means. And then as we have cases that go through the system, and you know
interpreting
this, right, and sure, as they go up to the higher courts, they become interpreted. So what had happened was with the retirement, the court decided that applied only prospectively. So if you were someone who got divorced prior to the act taking effect, you did not have the ability to terminate it when you reached that Social Security retirement age. So only for those people who have gotten divorced since the act took effect are able to use that provision. Under the prior divorces, they still can come in on what we call a change of circumstances that potentially allows the court to modify your prior order. But so that's kind of where we still can have lifetime alimony if you were divorced prior to the act taking effect.
Does it matter if the agreement provided for a survival versus a merger?
It does.
We can talk about those.
And it does. So if the parties agreed that that provision of the alimony were to survive, then that's going to stand. That's something that the parties agreed to do. And really what that means is it's almost unmodifiable if it survived. And if it merged, it was modifiable. But we would be looking at modification provisions that existed prior to the act in those cases.
Okay. What did the Alimony Reform Act provide?
So I guess maybe some of the things that it changed is it now identifies 4 different kinds of alimony. It determined that all prior alimony orders would be general term. So that's the first category. That's the most common category, general term alimony. We also have rehabilitative alimony, we have reimbursement alimony, and we have transitional alimony. Now, those last 3 are less common. The last 2 really have to be on short-term marriages only. There are limited durational components of those types of alimony as well. So I think that's why most of them end up being general term alimony, because we're talking about marriages longer than 5 years, and most of the case law that is developed has been under the general term, and because all the prior orders were general term. So
let's work our way backwards through the 4 basic types of alimony established by the statute. So transitional alimony.
So transitional alimony is a periodic or a one-time payment that is designed to help a person, the recipient, transition to a different sort of lifestyle. But again, it's on a short-term marriage of less than 5 years. You can only get it in that circumstance. And I think the durational limit on that is 3 years max that could be ordered. For someone who perhaps when they got married had a higher lifestyle that developed as a result of that, and now they are losing that higher lifestyle, it gives them a chance to say, okay, I'm going to have to, I have to cut back on some of my expenses, or perhaps I need to, not have this fancy car anymore. So it gives them that ability to, quote, transition. So again, fairly uncommon that we have that, but it can be important how you identify that alimony if you reach an agreement.
Now, reimbursement alimony is also fairly uncommon.
Yes.
What is reimbursement alimony, and when might that come up?
So reimbursement alimony is kind of what it sounds like. So if the recipient of that alimony, perhaps, I guess the most common would be is if you helped your spouse finish med school, right? And so you were working hard to help them pay for school so that they could, eventually come to have a career and increase their income or what have you. So that's a sacrifice you made. But it could be, non-economic sacrifices that person made as well. So it's really designed to, quote, reimburse them for those expenses that they outlaid for the other spouse.
So I guess it's more of a idea of what's fair is fair. I've been receiving the benefits of these payments for my education, and now that the divorce is occurring, I'd be looking to you would be looking to be paid back.
Yes, and fortunately there are circumstances where somebody might get married and say, oh, this is a good plan for me. This person will be able to allow me to do that. They can pay the rent or the mortgage and help me with school, but then when I'm done, perhaps the marriage is not as beneficial to me.
Right, exactly.
Yeah.
A little more common, but certainly not as much as general term, is rehabilitative alimony. And what is that?
So rehabilitative is designed to help a person not transition, but we have something in mind that is going to allow that person to become economically self-sufficient. So we may be talking about retraining, we may be talking about finishing a degree, getting a job. Some of those are the kind of things that we can, in the future, see in short term that this person will be able to provide for themselves. Okay, so it's somewhat of a transition, but they're not transitioning to a different lifestyle. It's just getting them over that hump to get to that goal. So we usually are able to specify a date that somebody might pay alimony until the spouse receives their bachelor's degree.
How important is it to be able to specify a date of a determination as to when somebody might be expected to be back on their feet, so to speak?
Well, and they probably can't always give a date certain, but they might be able to say, well, I'm going to graduate in May of 2020. Okay, so then they might say until May of 2020. That person, you could still modify that. You could come back to the court and ask them to extend it if you were able to demonstrate why you were not able to meet that goal. You maybe, fell ill and you need another semester or something like that. So it's important, but it can be extended in that particular case. And
so rehabilitative alimony can be modified.
It can be modified.
With a change in circumstances.
Right. And
how about the previous two that we talked about, the reimbursement or the transitional?
Right. So let me look at my notes here. And again, I laugh because some of these we haven't even seen any cases come down on them because they're so uncommon. So in transitional, it can't be modified. Reimbursement also cannot be modified. But what's interesting is transitional, they can talk about it being extended where the statute doesn't say that. About reimbursement. So it kind of leaves a question open as to whether or not you could extend those. But it does say it can't be modified. So.
And it seems to me that reimbursement in any event is more of perhaps a division of assets issue that's taken care of at the time.
It could be, yes.
And so the change in circumstances really doesn't affect that. So that seems to be perhaps the policy behind why that's the case.
Right, and when we talk about merger and survival, the property division is something that can't be modified later. So, and they do interplay a lot, division of property with alimony. So that's a good point.
They used to be under the same statute until the reforms.
No, and it still is. It still is.
There are additional statute sections?
There are new sections that again define the different kinds of alimony and the durational limits that we have on alimony, and some of those are new sections.
In section 53, that deals with the general term, is that right?
Right. General term alimony is under section 53.
Okay. What is general term alimony?
So that, again, is periodic payments. It does not say that it's a one-time payment, so I suspect it couldn't be that, although we do sometimes have an alimony buyout. But again, under the statute, it would be questionable as to whether if you had an alimony buyout, you could declare it as alimony and get the tax benefit out of that.
What is alimony buyout?
So you might say, oh, well, I'm entitled to alimony, but somebody says, well, I don't really want to pay alimony. I would just as soon give you one big lump sum and never have to come back about this again, right? I don't want to have to send a check every month. I don't want to be financially tied in that way. I would rather buy you out of that obligation.
And because alimony is deductible for the payor, you're saying that there may be a question as to whether that buyout becomes
right, or is it still general term if you do that? And again, because it's not specified in the statute that it can be periodic or a one-time payment, it just says periodic. So again, that might be something where we're waiting to see whether that ever becomes an issue that the courts have to interpret it.
Okay. So general term sets a term depending on what?
The length of your marriage is the key component as to how long the duration that someone would have to pay alimony. The way it breaks down is of marriages less than 5 years, all right? The maximum alimony duration would be 50% of the number of months of your marriage. So if we had 60 months of marriage, just at the 5-year mark, we could have 30 months where alimony could be payable. If we go from more than 5 but less than 10, then it goes up to 60% of the number of months. If we go 10 to 15, then it's 70%, 15 to 20 is 80%. And if you go over 20 years of marriage, that's where we call it indefinite. Okay, so potentially
up to the time of retirement.
Retirement, right. And that really seems to be a mandate that it terminates on someone reaching the payor, reaching their Social Security retirement age. There is some discretion with the court for someone to be able to extend that.
Under what circumstances?
So somebody would have to, perhaps it's a disability, perhaps it's, continuing need. But the court, if they do that, needs to have a written finding. There has to be good cause shown.
Right.
So we sort of expect that we won't have that, but maybe in some extraordinary circumstances that you could ask the court to extend it. The court can also extend it initially. When they first enter that order, they could say, I haven't seen that happen yet, but they could extend it at the very beginning. But again, they would need to do a written finding as to why they were doing that, why they were extending it.
Okay. So we have the terms as set by the length of the marriage. What are some of the other provisions within general term alimony?
So another one that is new is that the statute now says that if someone were to cohabitate, to maintain a common household for longer than 3 months, that alimony shall be, so mandated, to be reduced or suspended or terminated on that cohabitation. And previously, cohabitation was an issue at times, and someone would come back, and a lot of times someone would cohabitate and not remarry, because remarriage seemed to be much more of a trigger to terminate.
Sure.
Now it is a mandate that it triggers. It now terminates on remarriage automatically.
Does it do so automatically, or do you have to go in on a modification?
Well, I meant that it's a part of the statute that it happens.
Understood.
It's a question of strategy, I guess. I mean, I feel you're always safer to go in, right, and have an order that says it's now terminated, rather than, take your chances. It's just cleaner that way.
So again, dealing with issues of fairness, people cohabitating and not getting married in order to avoid giving up that alimony. Now it's addressing that issue.
Right. Right.
Again,
and there was a case that, because it was questionable to some degree as to whether or not someone takes on a roommate, somebody who moves in with their sister, right? Is that cohabitation? But there was some case law that came down that definitely made it seem like it was not just an economic interdependence or dependence upon one or the other, but that there be some more of a marital relationship. Okay, so looking at a number of factors so we're talking about a romantic
relation.
Really, yes. And the cohabitation, again, it can be reduced. It doesn't have to be terminated. And if that cohabitation were to end, the alimony could kick back in if the person came into court and asked for that. But the durational piece would still never extend further than it had from the original order. So if we had a 5-year cohabitation, that 5 years would be eating into your alimony duration as well, even if it wasn't being paid.
Okay.
Does that make sense?
Yes.
Okay.
Okay, so now the idea of cohabitation and how that plays into the length of the marriage. So if somebody were living, two people were living together, then they get married, married for a period of time, and divorced. Does that cohabitation period come into play?
So it can. So if there was a period, we're talking sort of a significant period, not 2 weeks before the wedding they moved in together, but and it happens more and more. So the court sort of acknowledges that, the statute acknowledges that, and it can increase the length of the marriage. And prior to the Alimony Reform Law, it was, you know what day you got married and that was it, and we know what day you get divorced. Now the statute says the day you're married until the day that the papers are filed, okay, and served, which keeps it from continuing in the litigated period. But it does also say that if there was a premarital cohabitation and there was some economic, again, interdependence or dependence on one of them, that can be included in determining what the length of the marriage was. And interestingly, there was a case where, if I can remember the details of it, so the couple was married, and there was some premarital cohabitation, and they got divorced, and there was an alimony order. And then after a couple of years, they moved back in together and got married again, and then got divorced again. And so it was, what is the length of this marriage? Do we get to include these other periods? And eventually the court said, yeah, except for that part where they were not living together in the middle. But
so the marriage was told for a little while.
Yes, yeah. So
but they did include the older marriage period.
They did.
Wow.
They did. So Interesting.
Things
so
to consider.
that's where when the court comes in
Sure.
and gets these interesting fact patterns.
So what goes into the calculation of an alimony payment?
Okay, so the statute says that generally speaking, the alimony should not exceed a person's need and or 30 to 35% of the difference in the parties' incomes. So as a rule of thumb, we're almost always looking at that 30 to 35% of the difference in their incomes. And where I think the need can come into play is to making the argument that, well, my need is greater than 35%. And you would have to be able to demonstrate that. And the need is going to be measured by the lifestyle that the folks had during their marriage, which may or may not include all of the things that they spent money on if they were living beyond their means, excuse me. But typically we're looking at the 30 to 35%, and a lot of times it ends up settling at about 32.5% of the difference in their incomes. Yes, yeah. So only really in a more nuanced case would we be looking at need, and you can always argue that this would far exceed this person's need.
Okay. And a lot of cases you have child support that plays into the mix as well. And how is that a factor in the determination?
So if there's a situation where there is child support being paid, the child support guidelines say that the child support applies to the first $250,000 of combined income, and that was really designed to capture those cases where there wasn't a marriage but there were children, and so that person couldn't get alimony, so we increased the child support limit. So again, we think of only if the combined income is over $250,000 will we then be looking at an addition of alimony. So you're paying child support and then alimony on top of that. And the alimony now says if you look at $250,000 or whatever you've used to calculate child support, we're not going to again count that in determining what the alimony payment would be. So we can always allocate those two in a way that is beneficial to that family and try to keep as much money with the family and outside of the government's hands if we can. So even if there was a child support order of $500 a week and alimony would technically be $200 a week, you might say, I'm going to take that $700 and I'm going to split it 50-50. And that would be okay. The court would allow you to do it that way, to reap the tax benefits.
Regardless of how the child support guidelines play out, the court will allow some strategic planning as far as...
Absolutely, and you can have an accountant take a look at it for you and say, here, is there some sweet spot as to where I'm maximizing, shifting some income to the lower income earner, the lower tax bracket, saving the tax dollars, but there's enough there to meet that $700 net, if you will.
Sure. Do you recommend that an accountant become involved at that stage?
I do. And if we're talking about that kind of money, right? Child support plus alimony, it makes sense. It's why wouldn't you try to do the best that kept as much, even your family may not be intact, you want to keep as much money in the family as you can. And I'm an attorney, and I can tell you that it's an issue, but I can't calculate it for you. So I would recommend that somebody see their CPA and help them figure that out.
Perhaps working together with the attorney and the CPA.
And then it's part of the negotiation, part of the proposal that you might make, and you can present that to the court, and they are usually going to accept something like that.
Okay. All right. Great. Thank you. Yeah. Let's go a little bit more into modification.
Okay.
And the termination of general term alimony, and how that may play out prospectively versus retroactively. What have you seen as far as retroactive application of the alimony reform laws?
So again, we had some cases that said the retirement termination and the cohabitation are prospective only. Okay, so we can't go back and fix those. What we do is we go back and we modify those under the law as it existed at that time, which typically means a material change in circumstances if your agreement had merged, and then something more than a material change in circumstances if your agreement had survived. So But they do say, and there was provisions, it wasn't codified, but it was as part of the act, that laid out the dates for when, if you had a prior alimony order and that alimony order exceeded the durational limits. And when I talk about the durational limits, I'm talking about the 50%, 60%, 70%, 80%, not Social Security retirement age, not cohabitation. Those, they don't classify as durational limits, even though they do limit your duration. But it's just those percentages. And if the alimony order that you got in 1999 had you paying, quote, for lifetime, and that exceeded 60% of the number of months, whatever the case may be, that you could come in and modify. And they did stagger that so that the shorter marriages could come in and ask the court to address that earlier than the longer term marriages. So, but I think the last date for that was in 2015, maybe March of 2015. So at this point, anybody who had a prior order that exceeds, the court determines that in and of itself is a change in circumstances that would warrant a modification. Right.
So people had to get in under the wire in order to...
No, they couldn't file until then. They had to wait to file.
Okay.
And I think part of that was, people bargained for an agreement, and this was a surprise to some people.
Sure.
The court doesn't allow you to say, well, I wouldn't have agreed to that if I had known, because that would really defeat the purpose of the entire statute. If you could say, well, it doesn't apply to me because I wouldn't have bargained for this agreement. So I think they tried to give people a little bit of time to get used to it, a little bit of time where they could adjust before that they could come in and modify it. So, yeah.
Well, thank you.
But so some people say that was the only piece that is actually retroactive, and I can't tell you for sure that that's true. So, which is causing some concern for the bar as well.
Well, there's always a lot of litigation that a lot of arguments that can be made on either side.
Right.
Andrea, I want to thank you for
done.
joining us.
My goodness.
We're getting there. We're at the end of our program, and I think your expertise is certainly something that adds quite a bit to this topic.
Thank you.
I appreciate your joining us.
Great.
And I want to thank you all for your attention and your time in watching us here on Legalese. As I indicated, it is a presentation of the Northern Middlesex Bar Association. As I urge everybody at the end of these programs, if you have a set of facts that you have questions about, don't take our advice here. This isn't advice. We're just talking about general legal information. Go to your local counsel, talk to your attorneys. That's what they're there for. They're there to help you through a lot of these issues. Some issues may be cut and dried, some not so much. Talk to your attorney and they can help you through the process. On behalf of Andrea, the Northern Middlesex Bar Association, I thank you once again. Good night.
Thank you.